Hi, Ron, you there? Ron, you copy?
Can you hear me?
Call this meeting to order. Standing Committee on Economic Development and Environment to order. My name is Jackie Jacobson. I'm the MLA for Nunukput and the Chair Committee. Our first order of business this evening is we'll open up with a prayer, and I'll ask Mr. Johnson if he could do the prayer.
Dear God, please look over us and guide us as we work for the benefit of all the people whom we serve in the Northwest Territories. Amen.
Amen. Thank you. Our next order of business, the review and the adoption of agenda. Mr. Clerk.
Thank you, Mr. Chair. Committee has one item on the agenda tonight, a public briefing from the Honourable Shane Thompson, Minister of Lands and Minister of Environment and Natural Resources.
Thank you, Mr. Clerk. Additions to or changes to the agenda from the members? Okay, seeing none. Can we have the move the adoption of the agenda? Motion is order. Mr. Johnson, thank you. All in favor? Kevin, good, thank you. Having reviewed the adoption of the agenda, any declarations of conflict of interest? As and when? Today, the Standing Committee on Economic Development and Environment is receiving a Development Environment is a public briefing on the Honourable Shane Thompson, Minister of Lands, Minister of Environment and Natural Resources on the Northwest Territories Environment Regulatory Process Reclamation Securities Overview. Today's meeting is being live streamed on the Assembly social media channels. Any presentation materials will be uploaded to the Legislative Assembly's website. To respect physical distancing requirements, Minister and his witnesses are attending a video conference. I'd like to remind all members on our witnesses that all comments and questions need to be directed to myself as the chair. Both members and witnesses will need to wait to be recognized by myself before speaking. I'll now ask the members to introduce themselves and on the record, starting with MLA Knockleby.
Katrina Knockleby, MLA for Great Slave.
Rylan Johnson, MLA for Yellowneck North.
Amy Lazard, Advisor with Sketty.
James Thomas, Committee Clerk.
And I have a few members that are off-site. Mr. O'Reilly.
Thanks, Mr. Chair. Kevin O'Reilly, Frame Lake.
Mr. Bonnetrus.
Ron Bonnetrus, Dead Show.
Thank you, Ron. Thank you, members. I'll now ask the Minister to introduce him and his staff to proceed with the opening remarks in the presentation. Thank you, Mr. Minister. Mr. Minister, you could take yourself off mute.
It's off mute. It's off. Can you not hear us?
Yeah, loud and clear. Go ahead.
Okay, thank you. Good evening, Mr. Chair and committee members. Thank you for inviting us to speak with you today. Here with me today from the Department of Lands are Assistant Deputy Minister Jaylyn Robertson, Planning and Coordination, Mr. Blair Chapman, Assistant Deputy Minister Operations, and Ms. Lorraine Seal, Director of Securities and Project Assessment Branch. From the Department of Environment and Natural Resources, I'm joined by Deputy Minister Aaron Kelly, Mr. Nathan Ritchie, Acting Assistant Deputy Minister, Environment and Climate Change, and Mr. Brett Elkin, Acting Assistant Deputy Minister of Operation, as well my MSA, Jeff Ray. Thank you for the opportunity to provide an overview of the environmental regulatory process and Reclamation Securities in the Northwest Territories. We are pleased to provide committee with more detailed information about the regulatory process as a follow-up to the previous commitments that I made to the Standing Committee on Accountability and Oversight and Economic Development and Environment. Northwest Territories has a strong and effective regulatory system based on shared decision-making. The government participates fully in regulatory systems along with Indigenous governments and organizations, communities, federal departments, stakeholders, and other interested parties to who wise decisions are made about the use of our resources. We provide expert technical advice during regulatory and environmental assessments in areas related to our mandate. Our government is also taking action to strengthen and improve the Northwest Territories regulatory framework. This includes ongoing work on how the securities that we recommend to regulatory boards is calculated. The Department of Environment and Natural Resources and the Department of Lands work together to determine the amount of the Reclamation Securities for water license, land use permits, and leases for major projects in the NWT. Both departments continue to review and update models used to establish closure costs for development projects in the Northwest Territories. This ensures the security estimates are in line with the actual costs of reclamation. Both departments are also updating and strengthening regulatory and policy frameworks for managing land and water in the NWT, including various pieces of legislation and regulations. Before making a decision, the Minister must ensure that the GNWT has met its duty to consult with Aboriginal people and accommodate, if required. Aboriginal consultation and Indigenous engagement are essential to regulatory and environmental impact process in the NWT. The public is encouraged to participate in regulatory and environmental impact assessment processes. Public registries provide transparent access to information, including submissions from the GNWT. The GNWT is committed to managing a development responsible and protecting the Northwest Territories land environment through careful assessment and regulations. Mr. Chair, I would now like to turn to Jaylene Robertson, Assistant Deputy Minister of Lands, who will take you through the first part of our presentation. Thank you, Mr. Chair.
Thank you, Mr. Minister. Ms. Robertson?
Thank you, Mr. Chair, and good evening, committee. It's great to have the opportunity to provide this briefing to committee this evening. The following presentation provides a high-level overview of environmental regulatory processes in the NWT. The NWT regulatory regime is quite different from many other jurisdictions because it's both integrated and coordinated and is based on land claim and self-government agreements. Turning to slide number 2. A brief outline of the presentation is provided. First, how resource management occurs in areas with and without land claim and self-government agreements will be discussed. Then, a number of key aspects of the environment and how they are regulated will be presented. There's an emphasis on land and water board processes as this is the main regulatory tool for development projects in the NWT. The key pieces of resource management legislation in the NWT will be outlined along with a description of regulatory and environmental assessment processes. This will be followed by a description of regulatory processes for wildlife, forests, hazardous materials, and protected areas. Ministerial responsibilities related to regulatory and environmental assessment processes will be summarized for the departments of both environment and natural resources and lands. Slide 3 outlines that we're going to be moving into land and water board processes next, and we can move to slide 4. The NWT's land and resource regulatory regimes are grounded in land claim and self-government agreements and negotiations, as shown on the slide. The system in the Inuvialuit settlement region is based on the Inuvialuit final agreement. The rest of the system in the NWT, known as the Mackenzie Valley, is based on the Gwich'in Comprehensive Land Claim Agreement, the Satu Dene Métis Comprehensive Land Claim Agreement, the Tlicho Land Claims and Self-Government Agreement, and the Delaney Self-Government Agreement. These agreements create land resource management structures and processes. In the Mackenzie Valley, this resulted in the establishment of the Mackenzie Valley Resource Management Act, which is federal legislation. In areas without land claim and self-government agreements, interim agreements help to provide direction on how parties will work together when making decisions related to resources. 5 separate interim measures agreements have been signed among federal, territorial, and regional Indigenous governments. Agreements have been signed with the Acacho-Dene First Nations, the Deschaux First Nations, the Northwest Territory Métis Nation, the Athabasca Denisulané, and the Godel Dene. Land claim and self-government agreements outline the management of land and natural resources in the NWT, the rules for federal and territorial governments and Indigenous governments and organizations through resource management boards. Indigenous governments and public governments have the ability to nominate people boards, and those boards serve the public interest. Management boards recognize the traditional and local knowledge of Indigenous peoples and provides ways for Indigenous governments to have input into resource decision making. Another main feature of resource management system in the NWT is the integration and coordination of all aspects of resource management. For example, environmental assessment, wildlife management, and the issuance of land and water authorizations are coordinated processes. Indigenous governments have a role in all aspects of resource management, though there is no single leverage point for their participation. Broadly speaking, in both the Inuvialuit Settlement Region and the Mackenzie Valley, resource management boards manage regulatory and environmental assessment processes. The Minister of Lands and Environment and Natural Resources respond to their recommendations and decisions where applicable. Moving to page 5, and as mentioned, there are 2 separate resource management jurisdictions in the NWT with different legislation, the Mackenzie Valley and the Inuvialuit Settlement Region. The Mackenzie Valley Resource Management Act, commonly known as MVRMA, applies in the Mackenzie Valley and provides authorities to carry out land use planning, regulate the use of land and water and the deposit of waste, and if required, conduct environmental assessments and reviews of project, monitor cumulative impacts, and audit the function of the environment and the state of the environment. The MVRMA is federal legislation. However, the GNWT has legislative authorities under the MVRMA, such as the joint approval of land use plans. ENR and the Department of Lands have also been delegated certain responsibilities under the MVRMA as a result of devolution. In the Inuvialuit Settlement Region, the Inuvialuit Final Agreement provides for the creation of management bodies for wildlife, land, and environmental co-management in the ISR. The Federal Impact Assessment Act also applies in the ISR to provide environmental assessment processes that consider potential environmental, health, social, and economic impacts of proposed projects, as well as benefits. Additional legislation that is relevant to land and water processes include the Waters Act and associated regulations, which was mirrored upon devolution. It also includes the NWT Surface Rates Board Act, which establishes a surface rates board whose mandate is to resolve disputes between surface and subsurface rights holders. The Environmental Protection Act, which covers the discharge of contaminants to the environment. Land Administration Acts, currently Territorial Lands Act and the Commissioners' Lands Act. The Public Land Act received assent on August 21st, 2019. The Public Land Act will come into force once changes to the regulations are made and will replace the NWT Lands Act and the Commissioners' Land Act, early 22-23. Forest Management Act and the Forest Protection Act, which allows for the issuance of license and permits. Protected Areas Act, which allows for the establishment of protected areas in the NWT, including their management boards. And the Wildlife Act, which, among other things, requires the submission and approval of wildlife management and monitoring plans. Slide 6 covers consultation, engagement, and participation. Aboriginal consultation and Indigenous engagement are essential to environmental, regulatory, and impact assessment processes in the NWT. It is important for the people affected by land and water decisions to be involved in the process. The GNWT relies on board processes to assist in fulfilling its duty to consult Aboriginal peoples and accommodate if needed. Land and water legislation requires that processes are public. The public is encouraged to participate through public meetings and hearings and written submissions. Boards maintain public registries, mostly online, which provide transparency. All submissions from the GNWT and other parties and all regulatory decisions are available on public registries. Moving to slide 7. This slide depicts the preliminary screening process for land and water authorizations in both Mackenzie Valley and the Inuvialuit settlement region. Preliminary screening is the first step in the regulatory process for the majority of land and water use applications. Generally speaking, a preliminary screening is initiated when a proponent submits a land use or water authorization application to a land and or water regulator, and once an application is deemed complete and in conformity with the associated land use plan, if applicable. The regulator then distributes the application for public review and comment. Once the regulator receives comments from reviewers, including the GNWT, federal government, Indigenous governments and organizations, and renewable resource boards, it conducts its preliminary screening. A preliminary screening is most often conducted by a land and water board. In the ISR, the Environmental Impact Screening Committee conducts all screenings. Preliminary screenings are meant to be a cursory look at the project to determine if the proposed development might cause significant adverse effects on the environment or be cause for public concern. If the answer to the might test is no, the project continues on to the regulatory phase to obtain a land use permit and or water license. If the answer to the might test is yes, the project is referred to an environmental assessment. In the Mackenzie Valley, the assessment is conducted by the Mackenzie Valley Environmental Impact Review Board. And in the Inuvialuit settlement region, the assessment is conducted by the Environmental Impact Review Board. To note, roughly 95% of projects that undergo preliminary screening in the Mackenzie Valley are not referred to an environmental assessment. In the Mackenzie Valley, in instances where the GNWT has a concern, the GNWT may refer a project to EA. On their settlement lands, the Toledo government and the Delaney government may also refer a project for environmental assessment. The project assessment policy allows for ministers to recommend to the Executive Council that a project be referred to environmental assessment. However, the GNWT does not have referral authority in the Inuvialuit settlement region. Moving to slide 8. You'll see if a project is not referred to environmental assessment, it proceeds to the regulatory phase to obtain a land and or water authorization. Examples of activities that may require a water license include industrial undertakings, such as oil and gas exploration and production, mining and milling, municipal undertakings, power undertakings, agricultural undertakings, and miscellaneous or recreational undertakings. In the NWT, land and water authorizations are issued by the resource management boards, agencies, and regulatory authorities listed on this slide, with the exception of the Environmental Impact Screening Committee, which is only responsible for screening. In the Mackenzie Valley, land and water boards are court-like tribunals with 50% Indigenous nomination and 50% government nomination. Nominees do not represent their nominators. Board members act in the public interest. Resource management boards and agencies are largely responsible for the regulation of land and water use and the deposit of waste. They accomplish this through the issuance of land use permits and water licenses. Land use permits and water licenses include conditions that are intended to minimize environmental impacts. When developing permit conditions, land and our water boards distribute the application for public review and comment. Conditions in these authorizations may require monitoring plans, studies or reports, closure and reclamation plans, and require security to be bolstered. In some cases, federal departments such as Fisheries and Oceans Canada and Natural Resources Canada can also issue regulatory authorizations related to development projects in the NWT. Slide 9. We could move there, great, thank you. Slide 9 outlines the Department of Environment and Natural Resources role in the regulatory process and the specific reference to water licensing. The Minister of Environment and Natural Resources has authority for the approval of all Type A water licenses and undertakings on non-federal land as identified in the devolution agreement, and the approval of all Type B water licenses, where a public hearing has been held associated with undertakings on non-federal land as identified in the devolution agreement. Type A water licenses are for larger undertakings, while Type B licenses are for smaller scale undertakings. ENR staff provide technical advice and support to boards as part of the public water license review process, as outlined in legislation. Finally, ENR inspectors are appointed by the Minister of ENR. Inspectors conduct water license inspections and are responsible for compliance and enforcement. Moving to slide 10. This slide outlines the Department of Land's role in the regulatory process, with specific reference to land use permitting and land leases. Most Crown land is now territorial land, managed by NWT lands. The Department of Land issues land leases for activities on public lands. In the Mackenzie Valley, land use permits are issued by Land and Water Boards. In the Inuvialuit Settlement Region, lands issues land use permits. Land use inspectors are appointed by the Minister of Lands to conduct land use permit inspections and are responsible for compliance and enforcement. Note, the Department of Lands released its compliance enforcement ministerial policy on August 16, 2019. All land use inspectors and ENR inspectors have been cross-appointed such that they are able to conduct water license inspections as well. Moving to slide 11. If a project is referred from preliminary screening to an environmental assessment, the Mackenzie Valley Environmental Impact Review Board in the Mackenzie Valley or the Environmental Impact Review Board in the Inuvialuit Settlement Region will undertake an in-depth review of the project to ensure that concerns of government agencies, Indigenous people, communities, and the public are taken into account and to protect the environment from significant adverse effects. The boards must consider any traditional knowledge or scientific information that is brought before them. As mentioned in the ISR, both the IFA and the Impact Assessment Act may apply. If agreed to between the federal government and the Environmental Impact Review Board, the environmental assessment under the EIRB can meet the requirements of the impact assessment process. Environmental impact assessments look at impacts on people and the environment, which includes the protection of the environment from significant adverse impacts, the protection of the social, cultural, and economic well-being of residents and communities, and consideration of the importance of conservation to the well-being and way of life of Indigenous peoples. The GNWT provides expert technical advice to review boards in a number of subject areas related to its mandate during environmental assessments. The project assessment branch of the Department of Lands coordinates input of all GNWT departments to ensure that government speaks with one consistent voice. Environmental assessments result in a report of environmental assessment written by the review board that determines the significance of the impacts and makes a recommendation about whether the project should be approved as is, approved with conditions that mitigate the impacts, or rejected. The review board recommendation is then considered by the federal minister and a group of responsible ministers, usually including GNWT ministers, for approval. The Tlicho government also has decision-making roles on Tlicho lands. Though it is rarely being used, both the review board or the federal minister and the responsible ministers may order an environmental impact review of a project. environmental impact reviews may also be ordered in the Inuvialuit settlement region. An environmental impact review is a more detailed and comprehensive assessment conducted by an independent panel appointed by the review board. Once the environmental impact review is complete, the panel will issue a report with a similar ministerial approval process to that of an environmental assessment. Slide 12 describes the environmental assessment decision phase conducted by responsible ministers after receipt of the report of environmental assessment from the Mackenzie Valley Environmental Impact Review Board. The responsible ministers, both territorial and federal, must reach consensus on a decision within a 5-month time limit, with the possibility of an extension of up to 2 months. Responsible ministers decide if the report of EA can be adopted as is, or it should be sent back for further considerations, modified after consultation, or rejected and environmental impact review be ordered. The NWT Minister of Lands has the delegated authority to sign and coordinate government decisions for environmental assessments on non-federal land. Most environmental assessment decisions are signed by Minister of Lands with input from other territorial departments and federal responsible ministers. The NWT departments involved as responsible ministers for the decision phase depend on the subject matter of the environmental assessment. Generally, the Department of Lands and Environment and Natural Resources are involved. The Departments of Education, Culture and Employment, Health and Social Services, and Industry, Tourism and Investment have also participated as responsible ministers. Note that as part of this process, the government must meet its duty to consult Aboriginal peoples and accommodate, if needed, before making a decision on the report of environmental assessment. Slide 13. Slide 13 describes the environmental assessment decision phase conducted by government authorities in the Inuvialuit settlement region. Under the Inuvialuit final agreement, government authorities, territorial and federal, must consider the Environmental Impact Review Board's report and reach consensus on one of the following decisions. If the project should proceed, and if so, under what conditions, or order an additional environmental review. The NWT is a government authority in the environmental assessment decision phase due to its role in land and water authorizations in the Inuvialuit settlement region. Specifically, the Department of Lands issues land use permits on public land in the Inuvialuit settlement region, and the Minister of Environment and Natural Resources approves Type A water licenses and Type B licenses for which a hearing has been held. Note that as part of this process, the government must meet its duty to consult Aboriginal peoples and accommodate if needed before making decisions on the report of environmental assessment. Moving to slide 14. Slide 14 identifies the processes and obligations that need to occur following the completion of environmental assessment and ministerial decision in the Mackenzie Valley. There are parallel obligations in the Inuvialuit settlement region. All regulatory authorities must act in conformity with the government's decision on the board's environmental assessment recommendation. Specifically, regulatory authorities may be required to report on the implementation of mitigation measures. For example, an annual report on mitigation measures associated with the Sleech of All-Weather Road is required by the review board. Permits, licenses, and authorizations must conform with the final environmental assessment decision as signed off by a minister. Subsequent regulatory authorizations may involve additional public processes. For example, a public review of a draft land use permit or a water license at public hearings. The NWT inspects and enforces the terms and conditions of land use permits and water licenses. Non-compliance with the terms and conditions is an offense subject to enforcement. Now moving to slide 15 and the discussion of legislated timelines. There are legislated timelines associated with many of the land and water regulatory processes in both the Mackenzie Valley and the ISR. These timelines range from 42 days up to 2 years, depending on the type of authorization. Note that in the Inuvialuit Settlement Region, timelines are associated with Federal Impact Assessment Agency-led environmental impact assessment processes under the Federal Impact Assessment Act. It is also important to note that the Minister of Lands and ENR are involved in decisions with legislated timelines for water licenses, where a public hearing is held, and environmental assessments and environmental impact reviews in the Mackenzie Valley. For environmental assessments, the responsible ministers, both territorial and federal, must reach consensus on a decision within a 5-month time limit, with the possibility of an extension of up to 2 months. Mr. Chair, with your permission, I'd like to now pass the presentation to Dr. Erin Kelly, Deputy Minister of ENR, beginning on slide 16. Thank you, Mr. Chair.
Thank you. Go ahead, Dr. Kelly.
Thank you, Mr. Chair. On page 16, proponents are legally responsible for undertaking closure and reclamation in an environmentally responsible manner. This is set out in permits, licenses, leases, and associated management plans. The definition of closure planning is determining the optimal way of returning a disturbed site to its natural state, or which prepares it for other productive uses that prevent or minimize any adverse effects on the environment or threats to human health or safety. Closure planning is required to happen throughout the life of the project. Many closure and reclamation aspects of a proposed project are discussed and decided upon through the environmental assessment process. The proponent regularly updates its closure plans, and there are many opportunities for Indigenous governments and the public to provide input. Moving to slide 17. Security deposits are funds held by the appropriate authority, NWT, federal government, or other landowners, such as an Indigenous government, that can be used in the case of abandonment of a project to maintain and reclaim that site. Security is set in land use permits, water licenses, land tenure instruments, and in environmental agreements for development projects in the Northwest Territories. Security is held by the appropriate authority, by the Minister of Lands for land instruments, by the Minister of ENR for water licenses and environmental agreements, by landowners if the project falls on private lands, by the federal government if the project is on federal land. Security deposit amounts are calculated based on third-party costs to conduct reclamation, no assumption for salvage of materials or equipment, and mobilization of equipment and fuel for remediation activities. Security estimates include costs for project management, engineering, contingency, etc. And security amounts and their breakdown are available on board public registries. Moving to slide 18. In the Mackenzie Valley, Land and Water Boards set the amount of securities for most projects after conducting a public review. Following public reviews in the Inuvialuit Settlement Region, the Inuvialuit Water Board set security for water licenses. The landowner or manager, Inuvialuit Land Administration, GNWT Lands, or the federal government, sets land securities. The GNWT has several roles in security processes. The GNWT provides technical input to boards, including an estimate of the amount of security. The GNWT determines what form of security is acceptable. Cash and irrevocable letters of credit, or ILOCs, are the GNWT's preferred form of security deposits. The GNWT may also set and hold security under land leases. On slide 19. The GNWT works very closely with the Land and Water Boards of the Mackenzie Valley and the Inuvialuit Water Board to develop security guidelines and procedures. These guidelines and procedures are available on the ENR and Lands websites and on board websites. Initiatives currently underway include the development of the Mackenzie Valley Land Use Security Estimate Tool and User Manual and security holdbacks for mines. In 2021, the Department of Lands will be engaging on the development of securities and other regulations under the Public Land Act. The reclaim model is used to calculate security for development projects in the NWT that require both land use permits and water licenses. The model allows the user to split security based on land and water-based liability. The model includes line items and costs for the remediation of specific components, for example, open pits, underground infrastructure, water treatment, mobilization, demobilization, post-closure monitoring and maintenance, etc. The NWT currently holds a total of $673 million in security for projects in the Northwest Territories. Lands holds $105.5 million in security under land use permits and leases, and Environment and Natural Resources holds $567.5 million in security under water licenses and environmental agreements. The total can change based on board and GNWT decisions to adjust required security amounts. On slide 20, we're indicating that we'll now discuss other regulatory responsibilities, so we can move to slide 21, please. Land claim and self-government agreements establish the main instrument for wildlife management. Renewable resource boards make recommendations to the Minister of Environment and Natural Resources about the management of wildlife, fish, migratory birds, forests, and plants. Renewable resource boards in the Northwest Territories include the Wildlife Management Advisory Council in the Inuvialuit Settlement Region, the Gwich'in Renewable Resources Board, the Sawtoo Renewable Resources Board, and the Wakaji Renewable Resources Board. With respect to wildlife, renewable resource boards can establish policies and propose regulations respecting harvest of wildlife, including a total allowable harvest. Their decisions and recommendations are communicated to the Department of Environment and Natural Resources. The government retains the ultimate authority for wildlife management. On slide 22, ENR authorizes permits and requires plans under the Wildlife Act, such as hunting and fishing licenses, wildlife business permits, outfitter and guide licenses, and wildlife research and observation permits. As of July 2019, a Wildlife Management and Monitoring Plan, or WMMP, is required for development activities that are likely to result in significant disturbance or pose a threat of harm to wildlife, cause substantial damage to wildlife habitat, or significantly contribute to cumulative impacts on wildlife or habitat. WMPs help to ensure sustainable development by allowing developers to demonstrate how they will mitigate the impacts of their project, remain in compliance with regulatory requirements, and address public concern. The Department of Environment and Natural Resources uses the regulatory review processes conducted by land and water boards to inform the review and approval processes of a WMMP so that authorizations are approved in a timely manner. WMMPs are approved by the Minister of Environment and Natural Resources and are binding and enforceable. The Department of Environment and Natural Resources has preliminary screening obligations, issues authorizations, and requires plans under the Wildlife Act. The specific authorizations that require preliminary screening are defined under the preliminary screening requirement regulations of the MVRMA. On slide 23. The Department of Environment and Natural Resources issues authorizations under the Forest Management Act and the Forest Protection Act. These permits and licenses include burn permits, a number of timber permits and licenses, as well as forest research permits. The Minister of Environment and Natural Resources is responsible for the approval of forest management agreements that are entered into under the Forest Management Act. These agreements allow for a partner to have long-term rights to harvest wood from a defined area for the purposes of forest industry business development and growth. Prior to the issuance of commercial timber permits on public land within a land claim settlement area, Environment and Natural Resources has an obligation to seek the advice of the applicable Renewable Resources Board. In an effort to coordinate forest management, the Department of Environment and Natural Resources conducts planning in conjunction with renewable resource boards. ENR is required to conduct preliminary screenings for forest authorizations defined under the Mackenzie Valley Resource Management Act preliminary screening requirements regulations. On slide 24. Under the Protected Areas Act and consistent with establishment agreements negotiated with Indigenous governments and organizations, the Department of Environment and Natural Resources sets up co-management boards for each territorial protected area. Plans to set up co-management boards for the two newly established protected areas, Whadinanene and Tuyata, are underway. Protected area co-management boards consist of representatives of the GNWT and relevant Indigenous governments and organization partners and are unique to each protected area. Membership and roles of the Management Board are negotiated with Indigenous governments and organizations during creation of an establishment agreement. The Minister of Environment and Natural Resources and Cabinet approve GNWT appointments to Territorial Protected Areas Management Boards under the Protected Areas Act. Protected Area Co-Management Boards make recommendations to Environment and Natural Resources on how the protected areas should be managed through the development of a management plan. For example, a management plan may include policies related to tourism permits, zoning, and rights to occupy land. On slide 25. The regulation of hazardous materials is not conducted in a co-management context. ENR issues authorizations under the Pesticide Act, permits and licenses including a pesticide application permit and pesticide business permit. Results of ENR's preliminary screenings are shared with co-management boards, but these boards do not provide the Department of Environment and Natural Resources with advice on issuance of pesticide permits. Under the Environmental Protection Act, the Department of Environment and Natural Resources requires the submission of a spill contingency plan for operators of above ground and underground hazardous material storage facilities on municipal and commissioners' lands, operators who are generating or transporting hazardous materials to submit information in a standard form. ENR is required to conduct preliminary screenings for Pesticide Act authorizations defined under the MVRMA's preliminary screening requirement regulation. On slide 26, we're indicating that we're going to provide a summary of ministerial responsibilities. So we can move to slide 27, please. To summarize, the Minister of Environment and Natural Resources has responsibilities under land and water, wildlife, forestry, and protected areas legislation. For land and water regulation, the Environment and Natural Resources Minister, with the Lands Minister, is usually a responsible minister under the Mackenzie Valley Resource Management Act for a decision on an environmental assessment conducted by the Mackenzie Valley Environmental Impact Review Board. The ENR minister may also be involved in decisions on environmental assessments conducted by the Environmental Impact Review Board in the Inuvialuit Settlement Region. The minister is also responsible for decisions on Type A and Type E water licenses with a hearing on non-federal land that have been completed by land and water boards. For wildlife regulation, the Minister of Environment and Natural Resources is responsible for the approval of wildlife management and monitoring plans under the Wildlife Act. With respect to forestry, the Minister of ENR is responsible for the approval of forest management agreements that are entered into with partners under the Forest Management Act. For protected areas, the Minister of ENR and Cabinet approved GNWT appointments to Territorial Protected Area Management Boards under the Protected Areas Act. On slide 28, the Minister of Lands has responsibilities under land legislation. The Minister leads GNWT decision-making on environmental assessments in the Mackenzie Valley and the Inuvialuit Settlement Region. The Minister signs the final decision letters for projects in the Mackenzie Valley that are not on federal land. The Minister appoints land use inspectors, also known as resource management officers, and holds and approves the form of Reclamation Securities. The Minister has authorities for land administration, such as leases. And finally, on slide 29, thank you very much for your time today, and we would be pleased to respond to any questions you may have.
Thank you, Dr. Kelly. Thank you, Mr. Minister, and Ms. Robertson for that presentation. I just now open the floor to my committee. If you have any questions to my callers, I have you put on FB on our messenger for our group. So if you could just put up your hand too. Kevin, if you have any questions, any members have any questions for the presentation to either to the minister. Okay, I have a question. Clarification, Mr. Minister, in regards on page, I think it was 12. In regards, page 16. The GNWT Minister of Lands is delegated to authority to sign off and coordinate the government discussions for environmental assessments on non-federal land. And does that say that the minister has the authority to sign off on different projects on GNWT land instead to get the project going faster, or do we still have to consult? Thank you.
Thank you, Mr. Chair. Yes, we do need to consult. We need to go through the process, but for further clarification on the process and what we need to do, with your permission, I'll turn the floor over to Lorraine Seals. Thank you, Mr. Chair.
Yeah, thank you, Mr. Minister. Ms. Seals?
Thank you, Mr. Chair. Yes, for any project that is going through environmental assessment, the Mackenzie Valley Environmental Impact Review Board conducts a thorough public process, and the GNWT participates in that process and consults Indigenous governments as well. So the decision at the end, if the project isn't on federal land, then the Minister of Lands has the pen on the final decision letter back to the review board. And before the Minister of Lands signs that letter, he has to reach consensus with all of the responsible ministers from the Government of Canada and the Government of the Northwest Territories. So it's they make the decision together, and then the Minister of Lands signs the decision, and that's for all projects that go through environmental assessment. So private sector projects, public sector projects as well.
Just a clarification. The minister, the question was for the minister, does he have the authority just to sign off on territorial land instead of going to public consultation and review? If it's territorial land, I'm reading here that, correct me if I'm wrong, does he have the authority to sign off on different projects, or does it always have to go to screening? Thank you, Mr. Minister.
Thank you. No, we still have to go through the process and continue that. The Minister does not have sole discretion to fast-track projects. Thank you, Mr. Chair.
Yeah, thank you, Mr. Minister, for that clarification. Next on the list, I have Mr. Johnson. Mr. Johnson?
Thank you, Mr. Chair. Sorry, I was just checking my mic was on. Thank you for this presentation. It's helpful to kind of see all these moving parts. I think I understand our regulatory system pretty well, but then I sometimes forget just how complex it is. My first question is in regards to brownfield sites. I guess I'm just looking for a general update on any work that is being done in this area. And I would encourage the department to go look at all of the work that British Columbia has been doing on their brownfield sites. And I think this expands to all sorts of things. It expands to, you know, the abandoned gas station parking lot we have in town, which we may make a contaminated site one day, but I don't think that owner will ever find the incentive to remediate it. And then if you go a little further out of town, it applies to, Ptarmigan Mine, which may have some economic value or may be remediated. And there's this tension here of, with these brownfield sites, if someone wants to take it on and actually try and find some more mineral value in them, how do they do that without taking on all of the liability? So I know the people in this room understand this problem much better than me, but I'm hoping the minister can update me on any work to develop a brownfield site policy. Thank you, Mr. Chair.
Thank you, Mr. Johnson. Mr. Minister.
Okay. Thank you, Mr. Chair, for that depth of analysis and clarification. I'll ask Jaylyn Robertson to answer your question. Thank you, Mr. Chair.
Thank you, Mr. Minister. Ms. Robertson?
Thank you, Mr. Chair. Well, I'll try not to get into too much detail about approaches to contaminated sites management and those types of things. With respect to the question about the brownfields policy, it has been identified as a body of policy work that we'd like to have and are doing some preliminary research toward that goal. There definitely is a need for the Northwest Territories to take a look at a policy like that. There's a lot of work on our plate at this point already with some of the work around the Public Land Act and a number of other initiatives, and so it's not currently on our priorities, but it's definitely some background research is being conducted, and I appreciate the member's comment to look at some of the work that British Columbia is doing, and that would be the first step generally in policy work to do an environmental scan like that. Thank you, Mr. Chair.
Mr. Chair?
Mr. Minister?
Yeah, for further information, I'm going to ask Aaron Kelly to present as well. Thank you.
Thank you, Mr. Minister. Ms. Kelly?
Thank you. I'd just like to add to Jaylene's excellent answer that there have been discussions about setting up an interdepartmental working group to begin looking at this issue, and I think that a jurisdictional scan was one of the first topics that will happen. So BC will be looked at as well as what's going on for brownfield policy in other jurisdictions across Canada. Thank you, Mr. Chair.
Thank you. Thank you, Ms. Kelly. Mr. Johnson, follow.
Thank you, Mr. Chair. Yeah, I appreciate that. I would encourage the minister to, perhaps prioritize this a little bit. I recognize how busy departments are, and there's always more work to do. And, probably getting the Public Lands Act implemented is priority one. But I think we could reach out to the Land and Water Boards early, and the work with the EPA and the work with the Waters Act and the work with the MVRMA, I think all ties in, and this could have a lens. And so I guess I want to talk about one specific brownfield site, which is Ptarmigan Mine. It's one of these ones where we're kind of in this jurisdictional dispute between us and the federal government. This is the mine when you're just driving up the Ingram Trail on the right-hand side. This falls into that exact category where I either want the contract for remediation to go out, which is a good economic driver, and will mean that site's remediated, which has arsenic and which has a number of problems, or I want someone who is willing to see if there's any mineral potential in that old site to take it on, but right now it's in this impossible jurisdictional battle combined with this impossible kind of security battle. So can I have an update on what's going on with that site specifically? Thank you, Mr. Chair.
Thank you. Johnson, Mr. Minister.
Thank you very much, Mr. Chair. So we're working with the federal government right now. We're in the negotiation of the mandate. This is kind of out of the scope of what our presentation was about. And so we'll try to answer it, but we would, prefer if we can keep our focus on our presentation and get the information out that we require. So I think it's, I'll turn the floor over to Jaylyn. Thank you, Mr. Chair.
Thank you, Mr. Minister. Ms. Robertson?
Thank you, Mr. Chair. Within the devolution agreement, there were a few sites, we call them accepted sites, part C in the devolution agreement, that are still kind of subject to negotiations between the NWT and Canada, as the Minister mentioned. And so we are working toward kind of resolution of that, but of course, until responsibilities for those sites are defined and management responsibilities, we're kind of holding off until those negotiations are done, until any decisions about the timing for any remediation or the processes, et cetera, on those sites can be done. Thank you, Mr. Chair.
Mr. Chair?
Yeah, go ahead there, Mr. Minister. Thank you, Ms. Robertson.
Thank you. Just to build on Acting Deputy Minister Robinson's comments there, we, as the government of the Northwest Territories, do not want to take anything on without working with the federal government. I need to make that very clear. Right now, when we signed devolution off, there were 6 sites that are in the Young Life area, and we need to be working with negotiating with the federal government to come up with a mandate and how we're going to do it. And we need to make sure we get actual costs. And before we even get into who's going to look after it, clean it up, we need to make sure we have the process done in place so we have the value and mandate with the federal government, as well as we're making sure we have the actual cost of doing it. We don't want to be given dollars and not get the job done and then have to come back, because as soon as we sign off on it, it becomes our responsibility. Thank you, Mr. Chair.
Thank you, Mr. Minister. Next on the list, I have Ms. Knockleby.
Thank you, Mr. Chair. So my first question is about the review boards and the other boards. It's my understanding that they're not necessarily technical and they're appointed. So I'm just curious if you can expand a little bit on the supports and training that you're giving to them, considering that they're making decisions on environmental impacts and maybe don't necessarily have that as a background. Thank you.
Thank you, Ms. Knockleby. Mr. Minister.
Thank you, Mr. Chair. For that detail, I'm going to turn to Ms. Seals. Thank you.
Thank you, Mr. Minister. Ms. Seals.
Thank you, Mr. Chair. The board members are appointed, nominated, and by Indigenous governments and the public governments, and they come from a very wide variety of backgrounds. Some of them may be technical, some of them may be traditional knowledge holders. I think it's important to note the boards have their own staff, and they those staff have technical backgrounds generally, and the boards need to maintain independence from the parties to the process, which includes independence from government. So the boards also have the ability to hire their own technical experts if they don't have the knowledge in-house. Now, having said that, the GNWT does participate actively in the process and makes its technical expertise available through the written submissions and participation in public meetings and public hearings. So there is the board and makes recommendations that are intended to assist the boards in reaching wise decisions.
Thank you, Ms. Seal. Ms. Knockleby.
Yeah, for my next question, it's sort of around the land use permits and planning. In some of the larger areas, there seems to be a bit of a disconnect between municipal governments and the GNWT on the enforcement of GNWT regulations within city limits, and not a lot of coordination between that. I don't know how much that really happens in the small communities, but definitely in the in Yellowknife and probably others like Hay River. So can you maybe explain a little bit how you're addressing that situation and improving that communications between those two levels of government? Thank you.
Thank you, Ms. Knockleby. Mr. Minister.
Thank you, Mr. Chair. This is going to be kind of a dual response from lands and ENR, so I'm going to start with Mr. Chapman, and then after he gives some information, we will turn it over to Mr. Ritchie. Thank you. With your permission, Mr. Chair.
Minister, Mr. Chapman.
Thank you, Mr. Chair. With respect to any of the ongoing activities within larger communities, we have within the city of Yellowknife, we have certain determinations done under the MVRMA that allow for the city to take on certain permissions and authorizations. We don't have the same level of determination in some of the smaller communities. However, they have certain authorizations that they, obviously from a development control within the communities, that they take on for their own municipal purposes. There are certain thresholds that are defined under the Mackenzie Valley Resource Management Act that identify what does meet certain thresholds. So that's clearly defined, at least from our understanding. We also have ongoing dialogue and discussion with the boards themselves on a regular basis, as well as with communities when trying to meet some of their concerns related to development. Thank you, Mr. Chair.
Thank you, Mr. Chapman. Mr. Ritchie.
Thank you, Mr. Chair. And I'll just add a bit on from a water licensing standpoint. So if a municipality has a water license, then there are compliance and enforcement responsibilities for our water inspectors when it comes to use of water deposited waste, so source water, so the intake for drinking water for the communities, as well as deposited waste through the solid waste disposal facilities, as well as if there's a lagoon, so liquid effluent waste lagoon systems. So there are licenses that govern how much water can be used from what sources, as well as deposited waste and operation and maintenance plans for municipal infrastructure when it comes to solid waste and liquid effluent from domestic purposes. Thank you, Mr. Chair.
Yeah, thank you. Thank you, Mr. Ritchie. Just before we continue, I'm missing my 8 o'clock call with my son Joseph to say goodnight to him. So I'm saying goodnight to you, son. I love you, and talk to you in the morning. So I'd now next on the list I have Mr. O'Reilly.
Thanks, Mr. Chair. Yeah, I guess when I opened up and read the presentation, it's kind of like Environmental Management 101, which is fine. It's not what I really expected. I had hoped that we were going to have perhaps a more focused discussion on prevention and management of liabilities and contaminated sites, that kind of thing. But okay, now that we're here, I guess my first comment is I think it's a bit of a not quite right to call this an environmental regulatory regime, which seems to be common practice amongst some folks in our government. You know, on slide 5, there's basically the 5 items under the MVRMA. This is an integrated resource management regime that does include land use planning, land and water regulation, environmental assessment, monitoring of cumulative impacts, and then audit. So I guess I'm going to suggest to my colleagues, my friends in the other room, and you can't really use these terms, I think, interchangeably about an NWT regulatory regime when we're really talking about an integrated resource management regime. So anyways, that's my first comment. Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. Mr. Minister?
Thank you, and I thank the member for his comments. Thank you, Mr. Chair.
Okay, Mr. O'Reilly, you have another comment, or do you have a question?
Sure, thanks. Well, lots of comments, lots of questions. I think maybe this is another comment that I would offer. There's some discussion in here about how land and water boards set financial security, but there was really nothing in here about there's a very strong and interesting provision in the Inuvialuit final agreement. They have wildlife compensation provision in their agreement. It's brilliant, quite frankly, so that a proponent basically has to conduct a worst case scenario for some kind of an accident, a spill, whatever, or a combination of all of them. And then the costs or potential impacts of that on wildlife harvesting need to be basically calculated, and then a proponent's required to put up financial responsibility, or basically a security deposit, to match that amount. And if the actual damages are greater than that amount, guess who's actually on the hook for it? The government. So in any event, I didn't see any mention of that in the presentation anywhere. I assume that my friends in the other room are aware of that. Thanks, Mr. Chair.
Yeah, thank you, Mr. O'Reilly. Mr. Minister.
Thank you, Mr. Chair. We were asked to do an overview, and this is what we are providing. We are aware of this, and we're looking and trying to do best practices. But at the end of the day, what the member and committee should be aware of is that we will provide information to the boards, but they make the final decision on what the securities are. We try to provide the best information available to them, and in the past, sometimes they've come back with not the number that we've asked for, but I would say in the last, correct me if I'll get the department to correct me if I'm wrong, but for at least last 5 or 6 or 7 years, we've been the boards have been listening to us quite, I guess, listening to us and moving forward. So with that, I would just get, with your permission, I'll just get clarity from Mr. Ritchie there. Thank you, Mr. Chair.
Thank you, Mr. Minister. Mr. Ritchie.
Thank you, Mr. Chair. And yeah, I would echo what the Minister has mentioned. For the past several years, we've been working very closely, not only with the proponents, but with the boards on policies and procedures on securities, which have included our interest to ensure that third-party liability costs are included in board decisions when they set security amounts and water licenses. There have been instances in the past, and I'm talking years ago, where we have been providing estimates to the board, and the board may decide on a different amount. But that has seems to have ceased recently, and we've been working very closely not only with the boards but also with applicants and proponents to get as close as possible to the security amount. And where there are differences, we provide rationale to the board on why there are differences and why the government feels that our amount should be the one that is determined by the board and set in the appropriate permits so that we are not undersecured. Thank you, Mr. Chair.
And Mr.
Thank
Chair.
you, Mr.
Mr. Chair.
Yes.
And to answer the member's comment is, yeah, if the securities aren't there and we end up with it and the cleanup is more than that, yes, it's on to the government of the Northwest Territories. And that's why when we were talking about previous brown site things or sites, when we're negotiating with the federal government, we need to make sure that we get the true cost of what it's going to cost us to remediate it. Thank you, Mr. Chair.
Yeah, thank you, Mr. Minister. And ongoing, we can always book further briefings on a going forward basis. So, next on the list, I have Mr. Bonatrush.
Must be Mr. Chair. Can you hear me?
Yes, sir.
Okay. And must be to the Minister and his staff, both from Lands and ENR, for presenting to us tonight. I note that it states the land claim and self-government agreement establish the main instrument for wildlife management, and perhaps for a lot of other issues, because there's no settled claim in these areas. How does Lands or ENR work with non-claimant groups like the Techo and the Acacho? I see.
Thank you, Mr. Bonatrush. Mr. Minister.
Thank you, Mr. Chair. To high level, it's part of our co-management process. We work with our co-managed partners, and especially ones that are land claims or ones that don't have land claims. So we work with them. But for further detail, I'll ask Mr. Elkin to further expand. Thank you, Mr. Chair.
Thank you, Mr. Minister. Mr. Elkin.
Thank you, Mr. Chair. Yeah, to follow up on the comments made so far, certainly from when we work with wildlife, when we work with forestry, in the 4 settled land claim areas, the Renewable Resources Board are the main instrument. As was stated, although we have not got settled land claims in the other areas, we don't have that instrument. We act in the spirit of co-management. What that will mean, for example, under the Wildlife Act coming up actually next week, we have what's called a Section 15 meeting. We bring together all wildlife management authorities. We bring together all IGOs, even from unsettled areas, and work in this spirit. We take that input and we take that advice in making our decisions. At the end of the day, we still operate under the Wildlife Act or the Forestry Act, but we try to work in the full spirit of wildlife co-management. Thank you, Mr. Chair.
Thank you, Mr. Elkin. Mr. Bonatush?
Yes, thank you for that. I just wanted to touch upon, and I think my colleague from Frame Lake may elaborate more on this. It's regarding the Cameron Hills gas project. I know it was previously owned by Paramount Resources, which in turn sold off to Strategic Oil and Gas, which is claimed bankruptcy. But I'm wondering, my question here is, was there any consultations with the surrounding communities like Tequiza, Fort Providence, and Enterprise? Let's see.
Thank you, Mr. Bonatush. Mr. Minister.
Thank you, Mr. Chair. Could MLA Wanneroo clarify what he's talking about, the consultation process with those communities? Is it about the cleanup or about them using the land? I'm just a little bit confused. Thank you, Mr. Chair.
Thank you, Mr. Minister. Mr. Bonatush, clarity?
Yeah, I can take it. It's been a long day. I'm talking about everything to do with the project. From the time Paramount had it, and then it switched over to another company, and the current site conditions, the plans moving forward, all that type of consultation. Let's see.
Mr. Bonatush, Mr. Minister.
Thank you, Mr. Chair. So the process with Cameron Hills has gone through the regulatory process, but further clarity and to actually maybe talk about the history in that, I'll turn it over to Ms. Seals. Thank you, Mr. Chair.
Thank you, Mr. Minister. Ms. Seals.
Thank you, Mr. Chair. Yes, as the Minister mentioned, the developments at Cameron Hills have been through a number of environmental assessment and regulatory processes by the resource management boards. And as part of that process, government has certain consultation responsibilities, and the proponent is required to engage with Indigenous governments in the area on just about every component of their operations. So currently, the receiver for Cameron Hills is engaging with all of the Indigenous governments as required under its land use permit and water license, and all of the documentation and submissions are available on the Land and Water Board public registries. Thank you, Mr. Chair.
Thank you, Ms. Seals. Mr. Bonatush, you have a follow-up?
Yes, I'm not familiar with many of these processes here that you're mentioning, that ENR or the GNWT lands ENR don't have to consult with these communities except the receiver. I don't follow what you're really trying to say, or brushing it off on someone else. I wonder if you can just try to elaborate on this whole scenario to me, and whether the GNWT has made any effort to communicate or contact any of the surrounding communities that I've listed.
Mr. Minister.
Thank you, Mr. Chair. So I guess simply put, through the regulatory process, there is a consultation with the communities surrounding the area. So we do that. Now, also the receiver needs to do that work, and the proponent has to do that work. So they need to consult with it. It's not downloading it onto anybody else. It's part of the process, so they need to do that. As for the work, there's been work cleaned up, so the receiver has done the work. They've hired the companies to do the work, and for further clarification, I will turn it over to Ms. Seals. Thank you.
Thank you, Mr. Minister. Ms. Seals.
Thank you, Mr. Chair. Yes, as the Minister mentioned, the requirement to engage with and involve Indigenous governments and communities is a fundamental part of the process. The government relies on the board process to assist in fulfilling consultation obligations. If there's a gap in that process, additional consultation can be conducted. But currently, the receiver is responsible for the site, and they have been engaging as required by their land use permit and water license with the Indigenous governments in the area.
Thank you, Ms. Seals.
Mr. Chair.
Go ahead, Mr. Bonatouche.
Okay, so something's not ringing here very well in terms of the consultation process. As I know members of my community of Providence, which are downriver from the Kakiza River, the Kakiza River, which is downriver from the Cameron Hills project. That's just to alleviate any environmental leakage concerns. I know Cameron Hills, not many people visit the area, but I could be wrong. Because the receiver, we don't know who the receiver is. You know, our communities don't know who they are. I don't believe they've made contact with our communities yet. What is the government's role here in this process here in terms of notifying the communities on the process of consultation now? If you could try to clarify that for me. And also, if you could send to me in an email, I would appreciate that. Merci.
Thank you, Mr. Bonatouche. Mr. Minister, you get that information sent to our committee clerk, and we'll pass it on to Mr. Bonatouche, please, and thank you.
Yeah, we will get that information in writing to the committee. Thank you, Mr. Chair.
Thank you, Mr. Minister. Next on our list, I have Mr. O'Reilly.
Thanks very much, Mr. Chair. Yeah, just a comment to follow up on Mr. Bonatouche. I think one of the issues with Cameron Hills was that it never actually went through a real environmental assessment. It went through screenings, so on, but as a field, it never actually went through an EA. So there was really, just I think minimal consultation or sending of applications off and so on. But I think what Cameron Hills, though, does for me is highlight the fact that we don't really seem to have a good early warning system in place that starts to set off alarm bells before something becomes a public liability. So it happened with Cameron Hills. It happened with Cantong. I know that these are post-devolution. Maybe there was problems when we inherited the sites, but and questions around whether we should have even taken them. But I just don't get a sense 6 years after devolution that we actually have an early warning system that's going to prevent more liabilities coming our way. Can someone respond to that question? Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. Mr. Minister?
Thank you, Mr. Chair. I need to clarify some information here. So there was 3 environmental assessments done on Cameron Hills there. But for further details and answering your question, Mr. O'Reilly, I know Mr. O'Reilly, this is probably going to be something that we're both going to agree to not agree on. But I'm going to turn the floor over to Mr. Ritchie. Thank you, Mr. Chair.
Thank you, Mr. Minister. Mr. Ritchie.
Thank you, Mr. Chair, and thank you for the question. It's an important question, and just further to the process, or I guess the post-devolution aspect, at least of the Cameron Hill site. The site went into receivership less than 1 year after devolution, and they actually suspended operations a few months after the devolution date because the oil prices went down. But as far as early warning systems, as you were referring to, we are looking into this, and through our approach to contaminated sites in the north, we're looking at policies and procedures. We're doing a jurisdictional scan. Some of those pieces that we're looking at to develop would be procedures to track financial health of third-party operators in the approach to identify and monitor abandoned oil and gas sites. So through this work that we're working towards with, in cooperation with lands and other departments, we've struck a working group that's going to be working on these things, and we'll report to an ADM committee. But we are looking at these things. There are real areas that we should focus on, and thank you for bringing those concerns to our attention. We recognize that there could be some risks to some of these devolved sites over time, but we're working to address that situation. Thank you, Mr. Chair.
Mr. Ritchie, Mr. O'Reilly.
Thanks, Mr. Chair. I'll just ask one more, and because I don't want to take the whole time here. The other issue that I guess I've raised probably for the last 4 or 5 years is the need for some form of, dare I say, institutional control of industrial sites once their, remediation, whatever, is finished of them. Saskatchewan is one of the few jurisdictions that I'm aware of that actually has a system for doing this. Companies, when they're finished with the site, and there's not very many in the program so far, they pay a couple of different pots of money, one for regular care and maintenance and one for sort of unforeseen situations, like if a tailings dam burst or something like that. And then once you build up the pot of money for each of those kind of categories of things, then the government actually has some money to work with to manage a variety of sites. And it allows operators to ride off into the sunset, but then the public has some assurance that there's actually a pot of money to manage these kinds of sites. So is this something that we're ever going to start to look at? Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. Mr. Minister.
Thank you for this detail, Mr. Emily O'Reilly. I'm going to start with Mr. Ritchie and then, with your permission, turn it to Ms. Seal. Thank you, Mr. Chair.
Mr. Minister, Mr. Ritchie.
Thank you, Mr. Chair, and I think Emily O'Reilly is making reference to the Saskatchewan Institutional Control Program, and we're obviously aware of that, and through that jurisdictional scan I referenced previously in the previous answer, we'll be looking at options such as those programs to inform us on the policies and procedures that we develop in the Northwest Territories. But for further, maybe I'll turn it over to Ms. Seal.
Thank you, Mr. Ritchie. Ms. Seal.
Thank you, Mr. Chair. Yes, just to build on that response, we are aware of the Saskatchewan program and actually had a representative attend one of our public workshops a few years ago to talk about it. I think it's important to understand that in Saskatchewan as well as here, proponent responsibilities don't stop at closure, so there are post-closure requirements, so water licenses, land use permits, leases, so there's a lot of work after closure, and my understanding of the Saskatchewan experience is that a lot of the projects are in that sort of post-closure phase where they haven't gotten to a point where the government can take them on. So having said that, we're very interested in the Saskatchewan example, and that is something that we're able to look at or willing to look at down the line in the immediate post-devolution in land and resource management. We've been focusing on some of the fundamentals, like getting a Public Land Act in place, and ENR has also updated a number of its pieces of legislation. So this is something we're certainly aware of and are tracking. Thank you, Mr. Chair.
Yeah, thank you, Ms. Seal. Now, next on the list, I have Mr. Johnson.
Thank you, Mr. Chair. I think by starting with Ptarmigan, one of the accepted sites, I kind of delved into an area that is probably the most complicated of all the sites we have. But I guess I want to step back, and I appreciate all the work both of these departments are doing. I know, devolution was 6 years ago, which can seem like a long time, but it's also just kind of a short time in the length of the amount of work we have to do. But I'd like to focus on the federal government currently has over 1,643 contaminated sites in the NWT. They weren't transferred during devolution. They've done some really good work. Obviously, Giant Mine is one of our biggest economic drivers. But in this last round of announcements from the federal government, Alberta got millions of dollars. Saskatchewan got millions of dollars. The federal government is really pushing to remediate sites. They see this as an economic driver. And when I look at those 1,600 sites that the federal government has, and I know those staff, I know they're working hard, but they really need some serious money. Can I just have the minister speak to any lobbying efforts, or has he reached out to his federal counterparts to try and get those sites remediated? And let's, light a fire under them. Thank you, Mr. Chair.
Thank you, Mr. Johnson. Mr. Minister.
Thank you, Mr. Chair. So again, this will be ITI that's been doing the lead on it. But some of the sites, the sumps that we've seen in your riding in the Bodell, the owners still own them. They still have them. They're still active owners, and they may not be doing work to it, but they still have those sites in their control. So the ITI has broached that idea, and the money that just for Alberta and Saskatchewan got for the oil and gas sites are sites that are abandoned. They're not sites that are run by oil and gas companies. Thank you, Mr. Chair.
Thank you, Mr. Minister. Mr. Johnson?
Yeah, thank you, Mr. Chair. I recognize there is a number of sites that, still have owners, and that's great. Then they will ultimately, hopefully, remediate their sites. But the federal government also has a bunch of sites on federal land which they own, which were not transferred to us. And in the devolution agreement, upon them finally being remediated, they will be transferred to us. So I guess, can I just get an update on those sites, the ones that belong to the federal government and don't necessarily have owners? Thank you, Mr. Chair.
Thank you, Mr. Johnson. Mr. Minister.
Thank you for that that information. I'll turn to Deputy Minister Kelly. Thank you, Mr. Chair.
Thank you, Mr. Minister. Ms. Kelly?
Thank you, Mr. Chair. Those sites can range from a cabin out in the bush to the accepted waste sites that you talked about, where there's much more complex remediation required. And so the federal government, like the GNWT, has been looking at a risk-based approach. So what we can put forward here is that we are developing a process for when the federal government has remediated the site and brings it to the GNWT, for us to make appropriate decisions about whether we're going to accept those sites back or not, and whether there are long-term liabilities associated with those sites. So that's where our focus has been on. It's their role to remediate the sites, and then we have a process that we're developing for how we go through assessing whether we will accept them back or not. Thank you, Mr. Chair.
Thank you. Thank you, Ms. Kelly. Next question I have on the list. Put you back on the list, Rylan. I have Ms. Knockleby.
Thank you, Mr. Chair. I have a pretty specific question to my former occupation. I'm probably going to always ask this group when I get them in front of me. Are you going to look to remove environmental site assessment drilling from the land use requirements or permitting? Yeah, that's it. Any plans to do that?
Thank you, Ms. Knockleby. Mr. Minister.
Thank you, Mr. Chair. You're probably not going to like this, but that's the federal government right now. So right now that's what the federal government now if I get this wrong, somebody will correct me, but I think it's the MPR or MRVMA or whatever, or something like whatever acronym that is, but that's what them is out right now. So thank you, Mr. Chair.
Thank you, Mr. Minister. MVMRMA is up. So, Ms. Knockaby?
Thank you. I appreciate that. I was actually going to comment. I probably knew what your answer was going to be. However, I would just like to ask that you continue to maybe lobby for that or mention that to your federal counterparts, as it's just a lot of extra work for work that needs to be done. And nobody is really going to say, no, don't bring the drill rig in and find out if the ground is all contaminated. So I think that we could be hopefully looking to streamline that, but I understand the complexity of that. I just wanted to know if you could provide an update or a timeline, or I may have missed something, but when we could expect contaminated sites like regulations versus just the guidelines that is currently in place. Thank you.
Thank you, Ms. Knockaby. Mr. Minister?
Thank you for that answer. I'll turn to Deputy Minister Kelly. Thank you, Mr. Chair.
Thank you, Ms. Kelly. Go ahead.
Thank you, Mr. Chair. We have an approach and we're working on policies that will fit under that approach, but at this time, there's no specific regulations contemplated for contaminated sites. Thank you, Mr. Chair.
Ms. Knockaby?
Thank you, Mr. Chair. Just further to the comments around the Ptarmigan mine, I was glad to hear my colleague raise that, as there is tailings also right near the highway there, and numerous times I've heard, oh, that really great sandy area where we can take our ATV and go out and have fun. So I just wanted to maybe make a comment that I would also like to see Ptarmigan mine, at least the tailings around the highway there or the Ingram Trail, be cleaned up sooner rather than later. Thank you.
Yeah, thank you, Ms. Knockaby. Mr. or Dr. Kelly?
Thank you, Mr. Chair. I'll turn it to Deputy Minister Kelly. Thank you.
Thank you, Mr. Minister. Ms. Kelly?
Thank you, Mr. Chair. So as mentioned earlier, the Department of Lands and Environment and Natural Resources and others are working together on a negotiations mandate. The responsibility for those sites needs to be determined before remediation occurs. And we're at the phase right now where we're almost ready to bring a mandate forward to Cabinet, which will help us move forward on that file. Thank you, Mr. Chair.
Thank you, Ms. Kelly. Next on the list, I have Mr. O'Reilly.
Thanks, Mr. Chair. There's one area that wasn't really covered at all in the presentation, and that's air regulation. You know, we've had probably 3 or 4 different environmental audits over the years point this out as a glaring gap in our environmental management system. And in the 18th Assembly, ENR did quite a bit of work on this. They actually got to the point where they thought they might try to bring in regulations under the Environmental Protection Act to regulate air, and then it sort of got off the rails because from what this is me paraphrasing, and I hope I don't offend anybody, ENR wasn't prepared to sort of do it as a co-management approach like the land and water boards do and be open and transparent about it all. And it just kind of went off the rails. So as I understand it, now there's some sort of discussions happening with the land and water boards about whether they may do it or not. And then we're not going to touch the EPA now until the MVRMA amendments are done, which may mean, you know, I could see where air regulation is going to get delayed for another decade. Can someone tell me what's happening with air regulation? Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. Mr. Minister?
Thank you. I will turn the floor to Deputy Minister Kelly. Thank you, Mr. Chair.
Mr. Minister, Ms. Kelly.
Thank you, Mr. Chair. So we went forward with we consulted on an approach for air regulations. First, we discussed it with the land and water boards, and at that time, they didn't feel that they had the capacity or the mandate to include air regulations in the land and water board process. So because of that, we looked at an approach similar to some of the other, the Pesticide Act and other things that ENR regulates directly. When we engaged on that and consulted, we were told clearly that the preference would be that it would be through a co-management process. So we went back to the boards and again had discussions with them about how they felt that this could fit into the Land and Water Board process. The challenge now is where would that fit in legislation? Because the Environmental Protection Act is not a co-management piece of legislation, but the Waters Act is a co-management piece of legislation. This is why we had hoped to make progress on amendments to those pieces of legislation, but they're now intimately tied, because the question is, where does air regulation fit within those two pieces of legislation? And there's some significant conversations that need to be had with the boards about capacity and mandate related to air regulations. And because of other aspects of the Waters Act and their relationship with the Mackenzie Valley Resource Management Act, we need to ensure that we have an understanding of what's going on with the MVRMA, and then work on the Environmental Protection Act and the Waters Act amendments together so that we can find the appropriate place for air regs to fit into our legislative framework. Thank you, Mr. Chair.
Thank you, Dr. Kelly. Mr. O'Reilly?
Thanks, Mr. Chair. That's it. I need to go, and I want to thank everybody for letting me participate from home. Thanks. Bye.
Mr. O'Reilly. Okay. Any other questions for the minister, or seeing none? I'd like to, no further questions from the committee. Does the minister have any closing remarks to our committee in regards to what your presentation or any of the questions?
Thank you, Mr. Chair. Mr. Chair, I'd like to thank the committee for attending here today. And I know it's been a long, long day, and I appreciate the questions. We've made a commitment to you to get some information back to a question by Mr. Bonnaroo regarding strategic in Cameron Hills. We will make sure we get that information to committee. I'd also like to thank my two departments and the staff for the great work that they're doing. And finally, we're more than willing to have another committee meeting or briefing with you guys for further clarifications on issues. I know this was a 101. We tried to present it as at high level as possible, but with some of the questions, we may need to present with you guys or send you some written material for further explanation in some areas. So again, thank you very much, Mr. Chair, and yes, thank you.
Thank you, Mr. Minister. Regards to the questions that we do have outstanding with you in regards from Mr. Bonnaroo, just to make sure you get that to our committee clerks and they'll pass it on to us. I'd like to thank you, Minister, for joining us today and your staff, and have a good evening. Thank you, sir. This concludes the public portion of our meeting, and a motion to go in camera. Mr. Johnson. Thank you.